Hello and welcome to Absolute Trust Talk. This is our video podcast at Absolute Trust Council, and I'm Kirsten Howe here with Jessica Colbert. And we are going to talk about something that estate planners don't often talk about or don't like to talk about, which is, can we avoid probate without a trust? And we don't always, we don't 100% of the time do trusts for our estate planning clients, but it's probably 99 point something percent of the time. There are very unusual situations where we're okay with not setting up a trust. But today, Jessica and I are going to talk about the various techniques that you can use to avoid probate without setting up a trust. And of course, we're going to talk about why we don't like those techniques in many cases, just so you get the full picture. Okay, so let's start. Jessica, start walking us through these various techniques that people can use.
One of the first techniques that we'll talk about is beneficiary designations or a transfer on death, pay on death account. They act fairly similar. For retirement accounts, you wouldn't put those in the trust. Instead, you would name a beneficiary designation, which is you designating who you would like to receive that asset upon your death. Similar with life insurance policies, those typically wouldn't be owned by a trust, although they could be. And same thing, you would designate a beneficiary saying who you would want to receive that policy upon your death. Now, transfer on death and pay on death, commonly called TOD or POD accounts, act similarly, but you can use them for any type of financial account, like a checking, savings, brokerage account. And it's the same kind of idea where you're saying on your death, this asset will go to this person that you've selected.
Right. And just to reiterate, the retirement assets are never going to be transferred to the trust while the employee who owns it is alive, because that would trigger a big tax bill. So we never do that, but in the planning process, we want to make sure we've coordinated with that to make sure we have the right beneficiary named. The problem with planning based on beneficiary designations, whether it's a retirement asset, a life insurance policy, or some other kind of TOD account, is that it's a pretty blunt instrument. You name the beneficiary. Oftentimes they'll allow you to name a backup beneficiary, but that's it. You don't get to say, well, I want to hold that money in trust because this person is only 18 and I don't think they're mature enough. You don't get to say any of those things. You don't get to protect it from creditors, nothing. So it's a very blunt instrument. We tend not to like it, but it can work. It can work in certain situations. What's next? What's the next technique that we want to talk about?
Next is a technique that we never use, and that's a transfer on death deed, which acts similarly to what we just talked about, but it's for real property. So real property owner, they execute a deed that says that upon their death, they want their property to go to this specific person.
Yeah, and as Jessica said, we don't use them in our firm for a variety of reasons, which I'll start talking about. Again, just to reiterate, same with the accounts, transfer on death, the life insurance. It's a blunt instrument, and you can name who you want to get the property if you die. I don't think you can even name a contingent beneficiary. I think it's just that one person. And if that person dies before you, then you're back to square one. You have no trust and no death beneficiary. The other thing that people need to understand is that it really doesn't work with joint ownership. If you own property together with another person and you own it as joint tenants, when you die, even if you did record a transfer on death deed, it's still going to go to the joint tenant. So it really only works for a single property owner. And again, it's just a blunt instrument. Doesn't give you any flexibility. So we don't use it. The other reason, a big part of the reason I don't use it is because there are so many potential things that could go wrong that if I wrote a transfer on death deed for a client, I would then have to write like a 2-page letter explaining why I don't recommend this because I don't want to get sued by their children down the road if it doesn't work out. That's just my personal opinion about that. Okay, let's go on to our last technique.
The last technique we'll talk about are assets owned in joint ownership. And you kind of touched on this talking about deeds that are owned in joint tenancy, just like how you can own real property in joint tenancy. If you own a joint account with someone, that is a joint tenancy. So if you have a joint account with your spouse, maybe you have a joint account with your parent, upon your death, that asset would then become that other person's.
Yeah. And it doesn't matter what your will says. It doesn't matter if you have a trust. Nothing matters. All that matters is you owned that asset as joint tenants. And using this as a planning technique is a little sketchy because, so let's say, I'll give you the example, and we see this a lot. Mother owns her home and she only has one child. Why do I need to set up a trust? I'm just going to create a joint tenancy. So mother signs a deed that says, I now transfer this property to mother and daughter as joint tenants. So now they own it together. Okay, so first of all, that transfer is a gift. That's a taxable gift that mother just made to daughter. That has to be declared with the IRS. Secondly, now daughter is a co-owner of this property. And if daughter gets into trouble with creditors, they could come after that property. If daughter gets a divorce, that property is going to be something that the judge is going to take a look at in settling the assets between the spouses. So there's a lot of risk there that you're taking on, especially if it's your home that you live in, and you don't want that to be subject to somebody else's bad decisions. So we definitely don't like that. It's just risky. And I'm going to add in here that not only transfers on death do we not like these techniques for most of the time. Most of the time, we don't like these techniques. They're not our preferred technique for transferring property on death. They also they're less desirable for lifetime incapacity. So we, as estate planners, we have to plan for incapacity as well, not just death. And if you have assets that are not in a trust and you become incapacitated and somebody has to help you access those assets, they're going to be doing that using your power of attorney, which is a valid estate planning technique. Every adult should have one. But we do know that a lot of times financial institutions give people a real hard time with powers of attorney. But we see that our clients' children who go into the financial institution and say, my mom is now incapacitated and I'm the trustee now, much simpler. It's much easier. They are willing to deal with the successor trustee. They might get a little squinty-eyed when looking at a power of attorney. So you're not really doing yourself any favor on the incapacity side by using these techniques. Jessica, anything you want to add?
No, I think that you covered it.
Okay. So what would you say the takeaway is here?
The takeaway would be that these techniques can work only if, everything that you had planned goes exactly the way that you had planned. And, we encourage everyone to be very aware of the risks that are involved with it. If people die out of order, or like you said, creditors could be involved, just be aware of the risks.
Right. All right. Very good. Thank you, Jessica, for your insight. And thank you all for joining us. I hope you learned something, and we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. Don't forget to keep an eye out for our next live episode. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcounsel.com. Thanks again for listening. We'll see you soon.